All right, hello again. This is Ben Hitchcock Cross talking to you today. I've got a letter here from a motion actually from Michele Zaccard of House Counsel at the Wisconsin Department of Corrections. You may recall Michele Zaccard and her compatriot Andrea Olmanson from the Stolar hot mic judge hearing. Those are the attorneys on the other side there. Um, you may also recall her saying that she doesn't consent to me recording. This is the troop. The Zaccard was assisting um, Olmanson at that time, but they're the ones who called 911 on me because I said that Andrea Olmanson had done something which I believe to have been unethical in the hearing. She said that that was disorderly conduct and she didn't consent to hear that. Um, wow. They also sent me several letters that we've read on air threatening me with bar accusations. I do believe they filed a bar accusation against me, um, threatening me with First Amendment I mean, basically doing everything they could to shut this channel down and keep us from, as they said, maligning good public officials. Um, which then we sent them a demand letter, cease and desist letter, to stop violating our First Amendment rights and the First Amendment rights of my client, including Joanna Stolar, which not only in that case there with the hot mic judge, it was clear that not only was the Department of Corrections meeting on restricting our free speech, but also the Department of Administration, that's the Capitol Police, knew all about the YouTube and trying to shut us up for our YouTube activities. And also the Department of Workforce Development was also doing its own thing in conjunction with the Department of Administration. And we, of course, have found out that they all met and discussed these things. So that is not only a violation of free speech rights, a clear conspiracy against the Constitution, but sort of par for the course here. So what's going on here is that somebody is trying to represent DOC people who's not somebody who's not an attorney. Is trying to represent DOC people at the Wisconsin Department of Workforce Development, something that is 100% allowed. But the Department of Corrections can't have that and is trying to remove this representative. Now, there is an issue here, and I don't know anything about this case. I do know exactly who this person is who's doing the representation. Um, no question about it. And I know the original DOC people. I mean, I know who these people are, but I don't know any of the arrangements or facts or anything. I don't have really anything to do with them. You will note that I am a member of the guild, I being an attorney, and that's the whole point here is that these people are working together. This is a former DOC person, is working with other DOC people to advance their discrimination claims through the administrative law process, which doesn't require them to have an attorney, meaning they're workers working together. And of course, we all know both the Department of Workforce Development, for example, the Stephanie Brown letter, and where she expressly says that she's concerned that one attorney is representing more than one employee to the actions by the DOC and so forth. I really have to say, just generally speaking, this it's my opinion that this Department of Corrections legal team is completely out of control, and I think this letter will show it here. Now, what I was all trying to say is, it seems that there is documentation here that says that this legal um, representative took money from the people that she was representing. I think it's $200. I have no idea what that's for. Maybe we'll get into it. Maybe we won't. I don't have any response to this. I have not any of their side of the story, but there's documents here that make it seem like it's the case. I know that it's against the rules in the state of Wisconsin to practice law without a license. Absolute fact. I will tell you that I'm not, you know me, I'm not really for people being told what to do. Great stands for lawyer. But I will tell you that as somebody who's gone through the process, my feeling on after law school on whether law school is necessary to practice law or not was completely different. And now I'm training younger attorneys, and I can tell you that even it just blows my mind sometimes on what they don't know coming out of law school. So those are the issues that we're talking about. Now, you have a right to your own representative. That's very clear. You can choose whatever you want in civil court, in criminal court. You can choose whatever lawyer you want, especially if you can pay for it. You can choose to have yourself represent you. Now, there's an express rules that say non-attorneys can represent uh, complainants at the ERD, and they're basically saying that you need to kick her out because she's basically a pain in the ass. All right, let's have their own words. Do Equal Rights Division, Stephen Ross, Michele Zaccard. Do. Respondents' notice of motion and motion to exclude complainant's personal representative. This is just a big, huge waste of everybody's time. I don't believe that the Department of Workforce Development is actually going to exclude these people. I've fought with them on all these things, and they basically tell you it's the response that makes it clear that they got instructions from their boss that that's just not something we do. So we'll see. I mean, if they were to grant something like this, it would be a huge problem for them, because where would it end? The law clearly says they can have representatives. Unfortunately, it's not really clear what the parameters are. All right. By and through its assigned attorneys, Michele Zaccard hereby moves for an exclusion of the complainants Elizabeth Benulos, personal representative Cindy Irwin from this case. The motion is brought pursuant to 227461E and the motion codes. Okay. Hold on. Sorry. That's the odious catch-all. Regulate the course of the hearings. As grounds, therefore, the respondent states, yada, yada. This is way too formal. Every person who appears as agent, representative on, for, and behalf of another person. This is the Wisconsin statute here. Any firm, corporation, any action, firm, association, person, firm, partnership, association, or corporation, any proceeding in or before any court of record, circuit court, supplemental court commissioner, or judicial tribunal of the United States or of any state, in or out of court for compensation or pecuniary reward, gives professional legal advice not incidental to his or her usual ordinary business, and renders any legal service for any other person, shall deem to be practicing law within the meaning of this statute. Okay. And there's a penalty, which is apparently fine. Oh, well, let's see what they have to say. And Sam Sivian versus DOC, appearing for clients, this is Wisconsin Personnel Commission, the WERC. This is an administrative agency. Okay. Appearing for clients before administrative agencies and preparing documents for clients requiring knowledge of any legal principles not possessed by ordinary laypersons in exchange for compensation or pecuniary reward clearly falls within the parameters. Huh. Now, this is interesting because when I read this, I'm going to have to read this opinion here. Because when I read this here, it says any court of record that is not, absolutely not an administrative tribunal, circuit or supplemental court commissioner, not a or judicial tribunal of the United States. Nope. Or of any state. Maybe. Now, here's the problem that I have with that. I don't know what judicial tribunal is, but I can tell you this. An administrative hearing is not a judicial tribunal. It's a tribunal, but it's an administrative tribunal. It is not a member of the judicial branch. So we'll have to see what Simeon or whatever that one says. In or out of court. Okay. And then we get into, and then it says, I got it. Or who otherwise, in or out of court for gives professional legal advice, not incidental to his or her usual or ordinary business, or renders any legal services for any other person or any firm, partnership, association, or corporation. Okay. So this is renders any legal service for any other person. Okay. Got it. Here's, I think, where all this falls apart. And I'm sorry that you're watching me think here, but here's the problem. Okay. It lists court of record, circuit or supplementary court commissioner, judicial tribunal of the United States, or of any state, or who otherwise, and then it says in or out of court. And so that I think is the big problem there, because I guess the comma is the crucial question. Is that in or out of court? Does that otherwise just mean anywhere, or does it mean otherwise in and out of court? What does that mean? We're going to have to go look at this case. What else are you going to do? I'm interested. This is, of course, a DOC case, I'm sure, with these people on it, and we'll find out. All right. So this matter is on findings of fact. He retained Pastori Belaley to represent him and his Wisconsin Fair Employment Act complaint proceeding before the commission. Interesting. What year is this? 2002? Interesting. All right. He's not an attorney, is not licensed to practice law. And the provision of profession is not incidental to his usually or normal business or employment. I don't know what that means, but okay. Complainant have agreed that bail is to pay $20 an hour as acting for the representative. Got it. Even in 2020, that's a pretty good deal. As complaint now, I always say you get what you pay for legal advice. As complainant's representative, Belaley has been representing complainant for all purposes and performing such functions as preparing and serving discovery requests and responses, and engaging in communication with respondent's attorney and commission concerning legal issues, in which communications he has made legal arguments and cited cases and statutory administrative rule provisions. Okay. Let's be clear. Has been representing complainant for all purposes. Belaley notified respondent that he would be representing complainant at a deposition of complainant scheduled for 2023 and demanded that respondent pay him $100 an hour and $200 in advance plus travel expenses for attending the deposition and representing the complainant. Oh, all right. So they're trying to depose the complainant, and he's like, "Yeah, I'm coming, but you have to pay me $100 an hour, $200 in advance, plus travel expenses." Huh. As part of the discovery, he inspected documents held by respondent, requested numerous copies. He delivered a check written by complainants for $115 for copies. And then he said the following email to the commission. I'm asking for a telephone conference to address why the DOC charges for documents. That's what I was going to ask. Requested as discovery materials for cases filed in the commission. Further, by this email, I'm asking the DOC not to cash the check. Above all, I would like to stop payment at his bank for that check immediately till this motion is resolved by the commission. That's a little weird. Before we can issue another check, it's the we part. The DOC and other agencies have to prove that they are required the commission to pay. The DOC would not charge the attorney printing costs, da 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 da, and he cites a bunch of law. The complainant, this is hilarious. Complainant stopped payment on the check, and the DOC simply deducted the amount of the check from the complainant's salary. They've been playing rough for a while. The representative has been assessed cost in various proceedings before this agency and state and federal courts. He is in arrears $4,000. And this is 2002 $4,000. Opinion. The commission's rules provide that a party is entitled to appear in person or with the party's representatives in any case before the commission, except as otherwise provided by law. Now, that doesn't have that in the DWD one that we just read. Other agent of a party has been authorized by the party to provide representation. Now, the ERD one says that, but it doesn't have this in italicized part, we're authorized by law. Maybe that goes without saying. I don't know. Thus, the rules provide wide latitude for representation before the commission, with the proviso that the representation which is otherwise unlawful is not allowed. The statutes providing relevant, every person can be fined. We've talked about that. Since the representative does not have a license to practice laws as an attorney, his representation of the complainant is in violation of this statute, as if such representation constitutes the practice of law. It further follows that the representative is practicing law without a license if this representation would not be authorized under the rules, because it says otherwise prohibited by law. Do. And then he goes here. And we just went through this part of the statute, every person, and I gave you my spot on thing here. And then I'm like, well, since the commission is a proceeding, is not a judicial proceeding, I'm just going to skip through this because these are a lot of things that we talked about. Okay? Do. Now, here's where they're saying the representative's brief, the commission is saying shows that he's practicing law. Okay? The complainant wrote to the commission to excuse itself from investigating the case. Huh? Instead, the complainant would be represented by the representative. The representative offered that the complainant pay him $20 for the time he would spend either at the commission or when writing the brief. The representative became the full and authorized representative of the complainant. I don't totally understand it, but I think the representative wrote that. The representative developed and served extensive discovery on the DOC, and the representative signed the document. Now, that is something that I would totally agree with right there, 100%. I have no doubt about that. In my mind, one of the privileges of being an attorney is being able to sign a document on someone's behalf. I don't know that anybody has that ability. I don't. Now, there's plenty of times where there are by rule, statute, some other thing that says somebody can sign something on behalf of something else without having a power of attorney or being an attorney. Okay? But an attorney, all you have to do is say, hey, go ahead and sign this for me, and the attorney can just do that. It's one of the magic powers of being an attorney and why that license is so valuable. So I don't know, without saying whether or not somebody before the DWD can sign that discovery, I don't know. Right. You served exemplary, signed the discovery document, and the DOC responded. The fact that they responded doesn't really mean anything, but maybe, hey, as the discovery, as to the discovery that the deal was full of either gaps, right? He said he cited deficiencies. The DOC responses reveal that new information was required from the DOC, and the representative served a second request for discovery. Okay. At the pre-hearing commission that he would amend the complaint. An amended complaint was filed. I'm assuming that means that he signed the complaint for that person, but here again in the DWD, that wouldn't mean anything. That clearly falls within the parameters of this Keller case. That case applied this statute, the old one, and it held that included activities before administrative agencies. Now let's look. That is the Supreme, that's the law. Bam. It doesn't matter what I think when I read that. It doesn't matter what you think when you read that. Let's assume that they're not lying and that the Supreme Court said in 1963 that practice you can't practice before an administrative agency without a license. Where this comes up for me, and that's what I'm thinking about, is sometimes out-of-state attorneys come in here and play this game. Haha. Because the illegal practice of law includes the element of compensation, who otherwise, in or out, yeah, it's the pecuniary reward. Now, that would be the next question this would sign up for me. Is a $200 fee, I'd like to see what the agreement says, what it's for, a one-time $200 fee, is that pecuniary reward? Now, I'm getting paid 20 bucks an hour. That's pretty clear. But a one-time fee, that could be, it doesn't say you can't be reimbursed for your copying, I don't know, equipment expense, I don't know. But it's pecuniary reward. It says compensation. Well, let's see what the agreement says. Okay. It's logical to interpret the commission rule on representation as not barring laypersons from acting in a manner consistent with the task performed by the representative unless compensation element is present. Bam. Okay. When a compensation element is added, the commission rule and the criminal law are both violated. Okay. It's the compensation element. That's the tricky part. How to define that? Okay, the representative opposes this conclusion. All right. But his legal analysis isn't that awesome, and we disagree with that. I'm not going to get that far because I think I understood everything else that was there. So let's go back to our other document. All right. Appearing for clients before administrative agencies and preparing documents for clients requiring knowledge of legal principles not possessed by ordinary. That didn't say anything like that. There was nothing about knowledge of legal principles not possessed by ordinary lay persons. Didn't say anything about that. It said basically giving legal advice outside of your normal business in exchange for the compensation element. Okay. Denoting representatives engaging in chicanery constitutes. Oh, well, maybe we'll go look back at what this chicanery question. I like chicanery. Just copy that, Joker. Stand by. All right, here's the shade on the representative. In the commission's opinion, the representative's orchestration of this situation was highly improper. Oh, gosh. Okay. This is the whole check thing, the who's paying for the fees, who's not paying for the fees. They think that he's causing a problem for no good reason. Okay. If he disagreed with the DOC's that it would not provide he could have brought on a discovery motion without regard to this question. They don't have any problem with him signing the documents. They just have a problem with him Okay. He engaged in chicanery by tendering complainant's check in payment for the copying cost to enable but then stopping payment on this check. All right. That they're saying they believe that that was the purpose of that was to get the documents without paying for them. Chicanery. All right. Got it. He's also, I just want to say, here's sort of the subtext is this guy is not acting in a lawyerly manner, the representative. I mean, you would kind of expect that, but you can also see why the commission wasn't having that. Okay, so they talked about this chicanery as being egregious misconduct worthy of barring representative from continuing representation. Yeah, I mean, you can lose it. You can lose the right, and there's probably a higher standard for somebody who's not protected or under the bar. I can see that. Worthy of barring a representative from continued representation in both current and future cases, because they kicked him out basically. Mostly importantly, Sath Civam, jeez, Ben, shields both litigants of the commission from loose cannon representatives engaging in egregious misconduct. Didn't say egregious misconduct. All right, let's see egregious. All right, something else they ding the representative for is demanding, basically canceling the deposition because he demands payment of his fees up front, which that's not how it works, but I understand the feeling.